e non tolgo altro tempo agli autori del libro, che ringrazio particolarmente soprattutto per aver resistito allo stress e alle mail inviate più di una volta con la richiesta di riscrivere più volte i capitoli. Quindi ringrazio Natalia, Tamas, Vladi e Giacomo, ma anche Anna Lorenzetti, Borislava, Josef e Marco per questo splendido viaggio all'interno dell'Europa. E adesso do la parola a Natalia.
With this presentation, I'll try to acquaint you with the legal framework of protection of LGBT persons in Croatia, but very briefly, and with legal framework of mediation in Croatia. But the main goal of this presentation would be to acquaint you with practice and conclusions regarding mediation and same-sex couples collected during this research. Protection of LGBT persons include international law because it's very important. It has primacy over domestic law in Croatia, and most usually we quote European Convention of Human Rights together with the case law of the European Court of Human Rights in our job connected to LGBT persons and their protection. The Constitution of the Republic of Croatia also bans discrimination, although not explicitly, but as the list of grounds is open-ended, it also can be extended to include grounds such as gender identity and sexual orientation. Anti-Discrimination Act offers full protection of against discrimination based on sexual orientation and gender identity, but also other laws include ban of discrimination such as Gender Equality Act, National Minorities Act, Electronic Media Act, Asylum Act, Labor Law, but those are more sectorial laws, and they also ban discrimination inside of their scope. Life Partnership Act exists as of 2014. Life partnership is placed at the same level as marriage, except for access to adoption. In Croatia, same-sex unions were legalized as of 2003, but the Same-Sex Unions Act contained much fewer rights than the Life Partnership Act, and it did not provide registration. Mediation is regulated in Croatia with Mediation Act from 2011 and Family Act from 2014. Family mediation is newly established, and it has not been recognized before the Family Act from 2014, which does not mean that in family disputes mediation could not have been used. It was very often used, but general rules applied. Those two acts determine mediation and prescribe that mediation is a voluntary process, except for the first session of mediation in family mediation, which is obligatory. It's also confidential. Mediator in Croatia can be a person who is trained by an accredited institution and consequently included in the mediation registry at the Ministry of Justice. Also, no specific guidelines in any act in Croatia or codes of practice for mediators regarding mediation with same-sex partners exist. A mediated agreement in Croatia can be enforceable if it stipulates a specific obligation to act, such as an order to pay, for instance, and if it contains enforcement clause. For the course of this research, we invited many judges, lawyers, mediators to share their thoughts and their experience with mediation with same-sex couples. However, only 5 lawyers and mediators appear to have experience with disputes between same-sex couples. Two of these lawyers used mediation to prevent disputes. These lawyers explained their clients in advance that the process would be very long and that it would cost a lot, and after their session with the lawyer, they decided to enter into agreement regarding assets, and this agreement stopped mediation and any other process. So that was the case of mediation to prevent dispute. Two lawyers mediated the disputes which did not settle, and one lawyer tried to reach the settlement during the same-sex litigation about assets. However, the disputants did not settle. None of the interviewed couples had been involved in mediation or pre-mediation procedure. When we asked them why is that so, they said that they prefer to solve their disputes in family circles and in circles of their friends. Mediators, what we can conclude from these statistics is that mediation is very rarely used between same-sex couples in Croatia. Causes of separation between same-sex couples are most usually domestic violence, coming out, open relationship, drug abuse, and alcoholism. In one of mediated cases, open relationship was an issue. Although partners, when they tried to practice open relationship, soon they both realized it's not what they wanted, but their relationship was at the point damaged to the extent that there was no return. So it was the cause of separation between same-sex couples. Coming out, it usually hurts feelings of other partners if one partner does not want to reveal his or her sexual orientation. Domestic violence and drug abuse are more self-understandable, so I will not explain it here because we don't have much time. Once a couple separates, dispute mainly arise about finance, and all those mediations that were explained are actually about finance. Once they decide to use mediation, source of power imbalance is most usually different financial situation of the partners, stronger character or communication skills of one partner, and maybe significant support from family and friends of one partner against another. Mediation turned to be impossible in cases of domestic violence and in cases of strongly opposed interest between the couple. In domestic violence, one mediator said that once she revealed that few scenes of domestic violence happened during the couple, she immediately terminated the mediation and she gave this person contact of legal aid. Strongly opposed interest between couple. An example is one mediated case where one partner actually did not want to settle but wanted to renew the relationship, and the other partner wanted just to resolve assets and their financial issues. Because their interests were strongly opposed, mediation was impossible. The conclusion is that no substantial differences between same-sex mediation and mediation between heterosexual couples exist. Approach to same-sex couples during mediation should be different because LGBT persons are a more vulnerable part of the society and their life in Croatia is more complicated than the life of heterosexual couples. Mediator should not be an LGBT person, but should be acquainted with LGBT terminology and problems specific for the LGBT community and person who has no prejudice towards LGBT persons. It's very important because one mediator said that unlike her, her colleagues who are also experienced mediators would never accept mediate same-sex couple. It was a shock to me because I thought that professionals would never act like that. A recommendation by mediators is to use co-mediation, and generally recommendation that we concluded that we have after this research is that due to specific problems of LGBT community in Croatia, it would be very useful to establish same-sex mediation center. Thank you. Thanks.
E ora dovrei dare la parola a Tamás, che ci offrirà un'analisi dei risultati della ricerca in Ungheria.
Welcome everyone, thank you for the invitation. My presentation will be a bit different. I will give a short overview of the legal situation, and I will provide you 4 case studies, 4 examples of mediated cases, and do a little bit of analysis of the issues at hand. The basic legal framework in Hungary is in place, which allows for a legal treatment of disputes that arise in same-sex couples. So in Hungary we had a registered partnership which basically grants all the rights that come with marriage except for parenting rights, so that this institution exists and people can use it. We have had cohabitation for quite a long time, so people who decide not to register their partnership are still recognized as cohabiting partners and thus have legal remedies to when they separate. And there is a law specifically on mediation which governs similar issues as the law in Croatia. So it sets up the minimum requirement of how to become a mediator, sets up a mediation registry, some quality management as well regarding mediation, and more and more in the Hungarian legal system there are very clear incentives to encourage people to participate in mediation instead of solving their problem through court procedures. So for example, in certain child custody cases it is compulsory to at least try mediation, and also the court can suggest to couples to mediate. So there's a very specific sentence in the Family Act, which the Civil Code and the Family Book in the Civil Code, which says that the court can suggest mediation to a couple if they see that this will be helpful. And also there are very clear financial incentives regarding court fees, which give an incentive to people to mediate. On the other hand, so the basic legal framework is in place, but actually these opportunities are not very often used. To be more specific, the number of people who entered into registered partnership is quite low in Hungary. So even though we had the legislation for over 5 years now, the number is still a few hundred only in the country of 10 million. So most people would stay in a cohabiting relationship rather than entering into registered partnership. The second one, that even though they are recognized as cohabiting couples, most people would not know that they are cohabiting couples and thus have access to certain court procedures when they have legal disputes. So they don't know about the fact that they are cohabiting or that they are legally recognized as cohabiting couples. And thirdly, mediation is very rarely used in Hungary, and specifically quite rarely used in family law cases. So the number of, not same-sex, but generally speaking, the number of family mediation remains in the number of a few hundred every year. So it's really a low number of mediation, even though there are these incentives which will result in a growing number of mediation cases, but so far it's still quite low, generally, not just for same-sex couples. So when we, based on the interviews, we basically the specificities of same-sex couples when it comes to mediation can be listed as follows, as opposed to mediation of different sex couples, where usually it is a divorce procedure which is preceded by mediation. For same-sex couples, since they use cohabit, or they are legally cohabiting only and not in registered partnership, there is this, so the mediator has to deal with the situation of an informal agreement between the partners about what their relationship is, and so even though there is legislation on what cohabitation means, people still move in this legal vacuum, at least that's how they understand it. The second very important aspect, of course, is that there is a lack of recognition for the non-biological parent, which then, with any parenting disputes, puts the second parent, so the non-biological parent, in a lot less powerless situation compared to the other person. Third one, there is a lack of culturally established norms of separation. So for divorce, everyone knows what divorce means. The family knows what it means, your colleagues know what it means, and people involved knows what divorce means. And for same-sex couples, those kinds of models of separation and divorce don't exist. which means that they are in a limbo. They don't really know what to do or how to deal with it emotionally, but also financially and in terms of their social environment. But it also gives them greater freedom in coming up with creative solutions to these problems. So this is a kind of a balanced situation, that there are no prescribed way to do it, which helps you to avoid the kind of mistakes that is usually culturally prescribed. One of the things that mediators very often mention is the difficulty to talk about relationships and emotions. So for mediation, it is always part of the mediation procedure to talk about what the relationship meant for you and to build some kind of trust between the partners based on a common understanding of what their relationship was, etc. And this proved to be quite hard, quite difficult with same-sex couples. So a few cases that I brought. These are 4 cases which are quite different from each other. The first one is giving you an example about how, when there is no children, things or pets can take the place of children. And this was very common in the interviews, that pets would take this role of children. So that the main goal of mediation was actually, besides settling financial issues, is to deal with the pets. How to organize a visitation, how to organize, even in this particular case, whether a new partner would be able to see the dog as well. So really using mediation, or kind of projecting feelings about children to pets in the procedure. Another case which concerns a gay couple who lived together for 8 years, and after 8 years the younger partner found out that the other partner was cheating all along the relationship. Not only that, but also this was a relationship with very clear economic imbalance between the partners. So one of them was in a low-paying job and taking care of the home, and the other one was a very successful entrepreneur earning a lot of money. And of course, when the younger one figured out that the older and richer one was cheating, he wanted to leave. But then there was this question, okay, so how to deal with this situation in which one partner was very rich, the other was very poor, and unlike in most mediation cases, it was not the poor partner who wanted to get money from the rich partner, but the rich partner saying, I want to offer you something, but the younger and poor partner was saying, no, I don't want to be paid off. But there was a debate about it, a real dispute between the partners, not in the I want more, but rather than I want to give more. So they then ended up through a quite long procedure of mediation in a very complex settlement on how to financially settle this issue. So only part of the money was paid actually, and the other part was given as a loan, so that the younger partner would at the end pay back the other partner for the amount he received for buying a new home. The third one concerns a case with children involved. So there was a lady a young woman with 2 children after divorce, and she entered into a lesbian relationship. They were together for 7 years. The children treated both of the women as mothers, and then they ended up separating. And then the question was, okay, legally speaking, the second mother doesn't have any duty to pay maintenance and have no right to see the child. At least at the time of this debate, that was the legal situation. So legally speaking, no one could claim anything from the other person. Not visitation rights and also nothing for maintenance. But the couple, and this was the luck for the mediator, agreed that they would treat this situation as if it was a common child. So that was the baseline where how they started the mediation. Luckily, because if that baseline was not there, there would be no chance of mediation. But there was this agreement there, but there was still quite a lot of disagreement about the actual amount of money to be paid. So then it ended up actually being very similar to any other mediation case involving children and disputes about child maintenance. So the mediator used exactly the same kind of techniques that would be used for a different sex couple. The interesting thing here was that in order to use this technique, this first baseline argument of we treat each other, or we treat our situation as if it was a heterosexual couple with a common child, that was needed for the mediation to work. And finally, a very interesting case in which the restrictive adoption legislation in Hungary means very interesting, or creates very interesting financial situations in which it was a lesbian couple who were together for over a decade. They decided to adopt a child. According to Hungarian legislation, only one of the partners can be the adopting mother. So they cannot adopt jointly. Now, in order to have better chances of adoption, they decided that all the assets will be legally under the name of the future adoptive mother. So they did this, they bought the house under the name of the future adoptive mother, the adoption was successful, and a year later they decided to separate. Now what was here, and what was the situation then, is that again, no right in terms of visitation, no right to, then the house was in a very tricky situation, not clear what to do with that, so both of them had very strong fears. The mother who was the actual adopting mother was afraid that the house will be lost, that she will not have any financial means to still be with the child. However, on the other side, there was also fears of losing contact with the child and of losing the house, to which she paid over half of the money. So here also the mediator had to deal with these very strong fears, which resulted from a lack of proper legal regulation on this parenting issue. So these were the 4 cases. You can read a lot more about it in the paper. So of course these were very brief introductions to the cases. And just to finish up, we came up with a few recommendations, mostly to government or legislator. First of all, to fully recognize same-sex parents. I mean, if there is such a strong imbalance, and that strong imbalance is created by legislation. It's not by nature, it is by legislation that this strong imbalance is created. So to get rid of that imbalance, because that's actually stopping a lot of people from being able to properly mediate. The second one is this fact that people don't choose to do registered partnership, mostly because they don't recognize they don't know about the possibility, or they don't recognize that actually it comes with a lot of legal security and actually rights that there exist, so that to do some kind of public campaign to promote the institution of registered partnership for same-sex couples, then generally to do legal awareness raising on the rights and duties on registered partners and cohabiting couples, because most people just don't know what it takes, what it means in case of separation, that they entered into these situations. To have better and easier to understand information on mediation, I mean the quality of the documents available, produced by the courts and by the Justice Ministry is not understandable in any way, so people don't understand what mediation would mean. And to do training for lawyers and judges on mediation, so that they offer this solution, and to do training for mediators on same-sex couples. Actually, the training that we did as part of this project proved to be quite successful and was very positively evaluated by those participating, so it seems there is a strong need for these kinds of trainings to happen in the future. Thank you.
Grazie, thank you, Thomas. E adesso noi la libreria.
Hello. I would just like to make sure that everybody's still in the house. So can I ask everybody that have a birthday between January and April to just wave the hand to the others? Between January and April.
Chi è nato tra gennaio e aprile?
Okay. Then can I ask everybody between May and August to wave? Let's see. Oh, much more. And then between September and December, let's see if winter is coming. Winter is coming. Okay, so now everybody, hello. Okay, so I will be brief as well, and I will try to speak much more about same-sex couples and mediation in Bulgaria, but to do that, I just need to go through a couple of steps so that you can actually perceive the situation. So we will go through a short introduction of the context, and then some very basic things in terms of what is the legal recognition of same-sex couples in Bulgaria, and what is the legal framework on mediation, and then we'll go to the findings of how those things actually combine and if they work together. So we are going to start with a short presentation on context, and I wanted to make this visual. So we are starting with this map. That is the IGLA map that is measuring how governments are succeeding or failing to ensure equality of same-sex couples. And as you can see, Bulgaria, that is over there, has 30%, 100 being the best of the best, and 30% is somewhere in the middle. It's the same color as Italy. It's still yellow, although Italy has a bit less percentage. But that's how it looks in terms of colors. And then in terms of words, what I would like to quote is something that we found through our research. This is a statement done by the chairman of the National Assembly, by the Parliament, who in the discussion of the new family code said we are a patriarchal society, and I think this says a lot, and I think we don't have to explain what that really means. Then the constitution does not, of Bulgaria, does not recognize, does not mention same-sex couples specifically, or LGBT people in general. It makes reference to forbidding discrimination based on gender, political affiliation, social status, and things like that, but does not mention gender identity or sexual orientation. And also the constitution defines marriage as a voluntary union between a man and a woman. So that means that if someday we are to change this, it actually has to go through changes in the constitution. That is not the best way, but okay. Then the only law that specifically mentions LGBTI people is the law against protection of discrimination. And since 2013, it is forbidding discrimination based on sexual orientation, and since March this year, they also included gender reassignment as a ground that you cannot be discriminated against. And this did not happen easily, but I will come back to that. Just remember that this happened a couple of months ago, and I will just tell you something more interesting about it. No, just a couple of words. No, I will skip that. So some thoughts about the content, since basically, sorry, legislation is put forward based on politicians or civil society. That's why I have these both actors here. So some thoughts on how these things emerge. Basically, there are no political parties that have the capacity to put forward legislation that would do that openly, from one hand, and on the other hand, the civil society, the LGBT civil society, is still a bit fragile. They're doing a lot, but it's still not enough in terms of actually putting pressure on decision makers to put forward legislation. I was actually doing the research as part of my cultural anthropology studies about collective identity of LGBT activists in Bulgaria, and the results of this research is that this collective identity is in crisis as well, but this is another subject. And then the final remark in terms of the context is that the legislation changing in Bulgaria, somehow trying to protect LGBT people or same-sex couple, always comes from more from the influence of European Union, and not so much because of changes of social perceptions within society that would put pressure on the government. And this is where I would come back to the gender reassignment ground for discrimination that was just included. The only reason why the first round that the members of the parliament voted the law, they did not vote the change through. The second one, the Prime Minister needed to come in to say that they need to do that because there is a European directive that they need to transpose it. And it was the only reason why gender reassignment was included as a ground for discrimination. So actually it's a very good example of how this thing works. Okay, we move forward to the very fast statement that same-sex couples are not recognized in Bulgaria, meaning that they cannot get married, but they cannot do civil partnership as well, basically like in Italy. And the only interesting thing is there is something that is called factual cohabitation. It is de facto cohabitation. So it is mentioned in a couple of laws, and I've given some example here, but the thing is that it is not legally defined. There was the attempt to be defined in 2009 when the new family code was discussed, when we were quoting before, but they decided that they will not define it, so right now nobody knows what exactly it means, but there are some consequences that are connected to that from a legal perspective. So we were hoping that since factual cohabitation is not legally defined, it can also include same-sex couples, but no. We were struggling for a while, but recently we found a case law on it. We found an injunction from the Sofia court, which is rejecting protection under the Act Against Domestic Violence, and the law and the court says, from the statement of the plaintiff, it is clear that she and the defendant are from one and the same sex. Our legislation recognizes only a marriage between a man and a woman, respectively. Factual spouses cohabitation can only exist between a man and a woman. So until there is something else that comes up, we need to stick to the fact that cohabitation only exists between a man and a woman. So as a result to that, that means that whenever same-sex couple tries to solve a dispute, either through mediation or in court, they can only do it as two independent parties, but the court would not recognize the intimate or personal relationship that they have between each other. So mediation is more or less similar like in the other countries. We have a law act on mediation. It is always voluntary in Bulgaria. Nobody can be forced to go through mediation, and there are not many incentives. As I'm referring to Tamas' case in Hungary, but there is a discussion going on to actually try to foster this. And we don't have a centralized statistics, but according to the report of the European Commission from the last year, we have less than 500 cases being mediated in Bulgaria every year. And we have more than 1,000 mediators trained. So that means that more than half of the mediators in Bulgaria in 1 year don't do any mediation cases. And it is also indicator of how much mediation in general is popular, but also that it is not very popular among same-sex couples as well. Because their relationship not being recognized, they can only solve anything as independent parties if they want for the mediated agreement to actually be enforceable. So I will just move forward to same-sex couples in mediation. Unfortunately, we were not able to identify couples that went through mediation. In some cases we were told, and you will not find it because it never happened. Maybe it happened, but even if it happened, the recourse to mediation in general is very, very limited among same-sex couples. And since we were not able to analyze cases, basically what we try to do is try to find the reasons why same-sex couples don't use mediation in Bulgaria. And these are some of the reasons that we found. From one perspective, there is lack of awareness about mediation. This concerns same-sex couples and heterosexual couples and basically everybody in Bulgaria, because as I mentioned, mediation is not used a lot. On the other hand, there is a preference for the dispute to be resolved without third intervention. The couples that we were speaking to were quite insisting on the fact that they should solve their disputes by themselves and they don't need help. There is still a concern regarding if a couple that goes to mediation or turn to any other help, third-party help, if they would face homophobia. So this is still quite an essential fear. And at the same time, they feel the need to maintain their privacy. Some of the same-sex couples that we spoke with were not open, or some of the partners were not open. So from this perspective, turning to mediation was something they would not do. And at the end, we found out that there is no specific guidelines for mediators to do mediation with same-sex couples. From one perspective, of course, such cases did not emerge, so that's why they didn't need them. But from another perspective, as soon as they do, they will not be prepared to do it. So it's good to start thinking about preparing mediators. And there is not a lot of information, well, there is no information materials at all about mediators in terms of how to do same-sex couples until Professor Muscati put up a handbook as part of this project that you saw. So this is something that we'll be promoting among mediators in Bulgaria. And just that's it from my side. Since I don't have business cards, you can take photos of this slide with my contacts. Thank you very much. I'll be happy to discuss all that.
Sempre creativo. Fantastico. E adesso finiamo con i dati sull'Italia.
Grazie. Siccome siamo leggermente in ritardo, credo io leggermente. Eviterò di fare la ricostruzione della parte su diritti LGBT in Italia, visto che siamo in Italia, quindi vi risparmio questa parte. Mi concentrerò invece sui risultati della ricerca empirica che abbiamo svolto sia tramite una ricerca bibliografica, ma anche tramite una serie di interviste fatte ad un trittico di gruppi, cioè gli avvocati e giudici, i mediatori e le coppie stesse. Allora, innanzitutto va detto che in Italia c'è la mediazione, ma manca la cultura della mediazione. Recentemente il legislatore si è interessato agli EDR, quindi ai metodi alternativi di risoluzione delle controversie, ma l'ha fatto sia per recepire alcune, in particolare una direttiva europea o comunque delle normative sovranazionali, sia per alleggerire il carico della giustizia civile. Manca, come dire, la volontà invece di introdurre quello che la letteratura internazionale chiama giustizia orizzontale, come opposta alla giustizia invece verticale, cioè il giudice che decide per le parti. Questo ovviamente si vede anche poi nelle coppie stesse, adesso arriverò a parlarvi anche di questo. In realtà la mediazione come parola a livello nominale esisteva anche prima del 2010, quando è stata recepita la direttiva 52 del 2008, ma era usato in modo non tecnico per indicare una soluzione bonaria delle controversie. Dopo il 2010 è entrata a far parte invece di un termine tecnico, giuridico in senso stretto, però come sapete la mediazione è obbligatoria soltanto per quanto riguarda le controversie civili e commerciali. La mediazione familiare rimane ancora largamente non regolamentata. Che cosa è emerso dalle interviste che abbiamo fatto a questi gruppi di mediatori, coppie ed avvocati? Allora, intanto è emerso che le coppie, persone dello stesso sesso, ma in realtà si può estendere anche alle coppie di persone di sesso diverso, lo stesso ragionamento, non sanno che cos'è la mediazione. Quando noi andiamo a chiedere cosa pensate della mediazione, una delle prime domande del nostro questionario, le coppie tendono a confondere la mediazione con la terapia di coppia. Al 95% pensano che sia una forma di terapia di coppia e questa confusione in realtà è in parte incentivata dal fatto che molti mediatori, che non sono avvocati, quei mediatori sono anche terapisti. Perché questo? Perché probabilmente la figura del mediatore familiare è una figura ancora abbastanza nuova e i primi professionisti che sono arrivati ad occupare questa posizione sono i terapisti. Per cui spesso accade, almeno quello che abbiamo riscontrato nella ricerca empirica, il mediatore che ha seguito la coppia l'ha seguita precedentemente anche come terapista. In realtà parte della letteratura sottolineava a livello internazionale che ci potesse essere un conflitto di interessi tra queste due figure, ma per quanto riguarda l'Italia devo dire che invece i mediatori hanno gestito perfettamente questo duplice ruolo e le coppie anzi non si lamentano di questa sovrapposizione di ruoli. Anzi sono abbastanza contente perché un elemento che viene spesso sottolineato dalle coppie è che i mediatori tendono a non usare talvolta una terminologia rispettosa del loro orientamento sessuale, non per pregiudizio ma per poca dimestichezza con queste tematiche. Per esempio una coppia dichiarava che la mediatrice da cui era andata a volte usava l'espressione il vero genitore, dove ovviamente uno dei due non era il genitore biologico, anche se lo faceva involontariamente senza voler offendere. È chiaro che tendeva a sminuire il genitore non biologico e questo chiaramente va poi ad impedire il raggiungimento dell'accordo di mediazione. E non a caso molte coppie, anche coloro le quali inizialmente confondevano la mediazione con la terapia di coppia, esprimevano una preferenza per un mediatore che fosse omosessuale, perché credevano che potesse essere, come dire, più sensibile a queste tematiche. In realtà chiaramente i mediatori intervistati e interrogati su questa preferenza delle coppie di persone dello stesso sesso, hanno reagito dicendo che è una cosa abbastanza comune, che riscontravano anche nelle coppie di sesso diverso con figli, in quanto queste coppie chiedevano al mediatore: ma lei ha figlie, non ce li ha, allora come fa ad aiutarci a mediare? In realtà mi raccontava un mediatore, non importa aver divorziato per comprendere come aiutare una coppia a trovare un accordo di mediazione che possa essere funzionale per magari mantenere sempre un rapporto con i figli. Esatto. Quindi c'è comunque un rapporto tra mediatori e coppie che in qualche modo va incentivato, e soprattutto è necessario introdurre all'interno dei corsi di formazione per mediatori anche una parte limitata, ma comunque una parte che è necessaria sulle problematiche specifiche delle coppie di persone dello stesso sesso, che sono in realtà in parte diverse da quelle delle coppie di sesso diverso. Molti dei mediatori intervistati non avevano esperienza con questa tipologia di coppie e dichiaravano che secondo loro i problemi delle coppie erano gli stessi. In realtà i problemi sono diversi, in particolare per quanto riguarda la genitorialità, in quanto c'è il problema frequentissimo del genitore non biologico, che quindi non ha a livello giuridico un diritto, almeno codificato, verso il minore, e questo può essere a volte usato come ricatto dal genitore biologico. È un tipico power imbalance che noi abbiamo riscontrato nella mediazione tra coppie di persone dello stesso sesso. Un altro può essere ovviamente quello che riguarda la proprietà dell'immobile. Se una coppia vive nell'immobile che però appartiene soltanto a uno dei due, in caso di rottura della relazione il proprietario tende a cacciare l'altro, il quale però, non avendo nessun legame giuridicamente riconosciuto con il proprietario dell'immobile, di fatto non riesce a ottenere niente attraverso i canali del giudizio ufficiale, quindi sarebbe importante in realtà che ricorresse alla mediazione. In realtà le coppie intervistate, o comunque in generale sul sondaggio che abbiamo fatto, tendono a non ricorrere alla mediazione per due motivi. Il primo è quello che vi ho già illustrato, che confondono la mediazione con la terapia di coppia. Il secondo è che c'è, almeno a detta dei mediatori, una certa ostilità con gli avvocati, quindi c'è poco dialogo in questo senso e l'avvocato tende a non mandare la coppia in mediazione e tende invece a suggerire un'altra EDR recentemente codificata, che è la negoziazione assistita. Abbiamo pochissimi casi di coppie che sono andate direttamente in mediazione senza passare dall'avvocato, e spesso appunto l'avvocato, vi dicevo, tende a non mandare in mediazione, sia perché è il suo stesso mediatore, sia perché a detta ora cerco di finire velocemente, sia perché a detta dei mediatori c'è un'ostilità tra queste due figure professionali, anche se la figura dell'avvocato è necessaria e indispensabile per ottenere un accordo di mediazione, perché il mediatore familiare, che non è avvocato, spesso non ha una conoscenza approfondita della legislazione della giurisprudenza, e quindi è necessario un intervento ex post dell'avvocato che controlli che l'accordo di mediazione non sia illegittimo, in particolare nei casi in cui ci sono dei minori, e i minori hanno, come si sa, alcuni diritti indisponibili che non possono essere in realtà oggetto quindi di mediazione. Quindi, per concludere molto velocemente il mio intervento, possiamo dire che per le coppie che sono andate in mediazione, in realtà la mediazione ha avuto successo,